Hi, everyone. Good morning. The 14th of November, finally, the DPDP rules are out. This is just going to be a very quick video run through. I'm going to be running through the rules along with you just to figure out what's the status of the new data protection rules, what are the key highlights, and how it's going to go. Starting off right off the bat, there are staggered staggered dates on which rules are going to be coming into force. So for example, 1 to 17 to 21 is directly in rule 4, which talks about consent managers is after 1 year from today. 3, 5, 6, 5 to 16, 22, 23 are going to be after 18 months from today. So somewhere about March 27. This is a lot of really cool significant developments. Point number 3, clause number 3, rule number 3 is really essential. Finally, there is a method in which notice is to be given, what it needs to contain, what is the language. It has to be clear, plain language. It has to have a fair account. That's a new term that they have used. And it should be in such a way that it enables data principle to give specific and informed consent. So it has to be an itemized description. It has to have a specific purpose specific description of goods and services for such processing. There has to be a link for a website or app or such for withdrawal of consent, exercise of right, and making a complaint to the board. This is again extremely significant because it is a notice plus a separate tab or a separate link to be done. This probably point 3C is works into as a window to go into how a consent manager works. Probably right now the way consent managers are going to work is they're going to help you manage consent as well as exercise rights and make complaint to the board. That's probably how it's also going to be. This is the first time that there is an actual rule for what a consent manager is going to be, what they need to do. In the schedules, you will see at the end of the rules, there are further more details about consent managers. The conditions of how consent manager can be is in the part A of the first schedule, and they have to apply to the board. Now that also means that if the rules are going to come in force in a year, that means the board is going to be functional within the year. So that's another significant development. So whatever, this seems straightforward. You apply. If there is an acceptance, there's an exception. There's a rejection, it's rejection. What are the obligations that a consent manager will do has to be specified in part B. We'll just quickly skip to that right now. If there is any, these are pretty straightforward. They may cancel, suspend, give any directions, and it can call consent manager to furnish any information. This is also a very interesting way of saying it, because the board also at the end of the rules, you will see they also have a power to ask for any data fiduciary for it. There's no date, there is no process, or there is no rule as of now which says that the board can ask a data processor to give any information. It's asking only for the data fiduciary. So that's going to be a very interesting method in which how the data fiduciary and the data processor interact. Let's skip to the schedule part A, part B of the first schedule, so that we understand how consent managers work. It has to be an Indian entity. It has to be net worth of 2 crores. It has to have capital structure, directors, key managerial performance with good reputation. It has to be a MOA and AOA, which definitely means that it's going to be a private limited, drawing from the Companies Act. And it has to be done for the interest of data principles. So probably if I am, say, a bank, I can't have a consent manager. Probably, these things are going to be figured out. Very key important part is that consent manager platform has to be interoperable. That is really interesting. There are going to be data protection standards and assurance frameworks that the board is going to give. So again, that probably indicates the board is right around the corner. There are rules about the board also. I'll quickly get into. TOM, technical and organizational measures, are also there. So there is a certification for interoperability and TOM, which is again a drastic change from other data privacy regimes. Now, what are the consent managers supposed to do? It's a platform where the fiduciary is onboarded, and they can either directly platform either directly to such fiduciary or through fiduciary onboarded onto such platform. Amazing. which basically means the entire consenting regime either is outsourced to a consent manager or directly managed by consent manager. Like a very Shopify, it's a very Shopify way of dealing consent probably. Uh, it has to be again. It goes to rule 3C. If you see, it talks about consents given. Consent manager should have a log of data about consents given, notices given, etc. It should be using a data principal. Should be using the platform. Very interesting because it talks nothing about data processors. Again, there is a log requirement for 7 years, so consent manager needs to have significant amount of data on their servers again. They have to have a app, website, or both, which is primary. They cannot subcontract or assign any obligations. Oh, that is also massive. So yeah, so they probably will need to have their own servers. We'll see how that develops, but probably the way it looks like, probably you can't have a cloud account. Again, this is just thoughts on the top of my head. We'll have to take a look at it. There has to be reasonable technical security safeguards. The rules define what these reasonable security safeguards are. It has to be accessible, all the information about consent managers. Every person who owns more than 2% of the shareholding of the company will have to be expressed and publicized. All information that the board says that you have to give will have to go. The board will give probably recommendations with respect to systems, procedures, etc. As I said, body corporate, which will mean Companies Act, everything from the Companies Act. Oh, okay. This is also very interesting. If you're a consent manager, sale, merger, or otherwise without approval of the board. So if you're a consent manager, if you're raising funds, if you're raising money, probably that this is something that will be of interest to you. Okay, let me quickly skip back to Rule 5 where we were. Let's go. Where is it? Right. So I'm going to skip this. I'm not sure if it's too much of a relevance right now, because probably whoever is reading it is not a state or a central instrumentality, that there is a rule about what kind of processing activities can be done, cannot be done for a subsidy, benefit, service, certificate, license, or permit. So this is like a leeway given to state entities. Very, very significant development again is something called reasonable security safeguards. So for the first time, I think in Indian law, apart from say certain or SPDI, there is an actual legal rule that talks about what security safeguards are. But again, the way we see it, it says appropriate data security measures. Okay, it says encryption, obfuscation, virtual tokens mapped out, that map out data privacy. Really progressive. Now, all of this should include at the minimum. So all of these are minimum. Oh, tokenized data mapping, data encryption is massive. Access control measures, standard. Visibility of who is accessing through logs and monitoring, standard. Reasonable measures for continuous processing in the events of confidentiality, integrity, availability of such being compromised as a result of destruction, loss, or access. Okay, this goes into the way of, basically they said you need to have data backups. Long story short. Oh wow, XDR, enabling detection of unauthorized use, investigation, remediation. Again, these are again standard security frameworks that GDPR also sort of utilizes in some way or manner. There is appropriate provisions, contract entered into between the data processor and data fiduciary for taking reasonable safeguard. This is massive. I'll say this is one of the most massive steps in these rules, because the DPDP Act per se has always been silent about what kind of contractual information needs to be expressed between a fiduciary and a processor. So this makes it really important, saying that okay, there are other technical reasonable safety safeguards that need to go there. Appropriate technical and organizational measures to affect observance of security standards, which is also security safeguards. Again, this is a little more random or a little more meta, but again, really important. Oh wow. Let's see if they have given a timeline for data breach. Yes, it has to be done within 72 hours before coming. The breach notification should include breach, name, nature, extent, timing, relevant information, measures being implemented to mitigate safety measures, business information, who's able to respond. So the next rule that you will see probably also say is a massive rule. All of this goes into the direction of you have to have a DPO. Again, there's going to be a lot of data protection work, officer work that's going to come about. So within 72 hours, you need to go to the board. Okay, I think intimation is immediate on becoming aware, and within 72 hours you have to write to the board, or within such longer period as the board may allow, about remedial measures, etc. So basically, you need to have given immediate response saying that okay, there has been a breach at our end, but there are 72 hours for you to get like a root cause analysis report done and understand everything, get mitigation measures done and write to the board. Time period for which specified purpose. This is again a great point for data retention and data deletion. So it basically says that it has to erase unless retention is necessary for compliance with any law. The exact time periods for data retention is mentioned in the third schedule to the rules. We'll just quickly scroll to that. At least 48 hours before completion of the time period erasure of personal data under this rule, the data fiduciary shall inform data principal that such personal data is being erased unless she logs into the account otherwise for performance. That is incredible. This is incredible. This is actually a departure, significant departure. Probably what's going to happen because of this is when the rules come in. This is rule 5, rule 8. So there's an 18-month period before which it starts. So we are looking somewhere about April 27 for this to come in. So April 27 onwards, everything will go on. Say you're an e-commerce platform, you have 3 years to reduce it, keep it. So probably April 30 is when you'll also, be like, either there is continuous use that will give you each event for 3 years after that. So for example, if I'm ordering on Amazon continuously, probably that will be a trigger event for 3 years time period deletion after that. But basically, if there is an inactivity for the time periods mentioned in the third schedule, that's my understanding right now. We'll have to again do a very deep dive a little bit later on. But once that happens, we need to that where there are trigger events will sort of increase the limitation period. Yeah, this is I think one of the most significant update in this. This basically, in as many words, say that there needs to be a data protection officer. So every data fiduciary shall prominently publish them and mention every response to communication for the exercise of rights, the business contact information of data protection officer. In as many words, without making it as obvious, it says that every organization needs to have a DPO and every communication needs to have DPO information. This is incredible. Verifiable consent of child. So this was always a talking point. So it has to be identifiable. How will be identified? There has to be reliable details of identity available with the data fiduciary. So if I'm saying that, because there is a child of 7 years of age, he needs to, there has to be verifiable consent. The data fiduciary needs to have some sort of a logging system for this. Identity and age, voluntary provided by the individual or virtual token maps. Again, amazing. Adult means somebody, all of this is fine. DigiLocker is also something that they have explicitly added into it. We'll just skip all of these cases. This is again for child or a person with disability who has a lawful guardian has similar set of instructions in the rules. Exemption from certain obligations of processing of child is also very important, which basically means which will be in the interest of child. There is again a schedule to this. We'll go to that. Again, unfortunately, we have an obligation which talks about additional obligations by significant data fiduciaries, but we still don't have a definition of SDF. We still don't know what an SDF is. It says that it will conduct a DPIA every year to ensure observance of the rules, and every DPIA shall be furnished to the board. Apart from that, it should have whatever due diligence activities with respect to technical measures, including algorithmic software. That's a great way of saying AI, adopted for sharing of data processed of the data principals, and that it does not possess a risk. I think this is what is more important. Rights of data principles is straightforward. It's coming basically from the Act. It says that that this part one talks about what the consent manager should do, and part two talks about what are the rights and how they're supposed to be given consent, etc. This again comes from the rules, so I'm going to just skip through that. Transfer of personal data out of India is again expressed here, but again it says that requirements as the central government may agree on. So the exemptions also come from the Act. Okay, 17 is also incredible because they are coming into force immediately, which basically means that there is an immediate going to be an appointment of a search and selection committee to have chairman and members. I am not sure if they have mentioned exactly how many members are there going to be. It just says, yeah, it just says, secretary and cabinet secretaries are going to be there. This is entirely going to be a board completely appointed by the government. There's no judicial presence here. Okay. Apart from that, there are salaries and allowances. Procedure for meetings, again, this is not really relevant for us today. Functioning is of board office. Yeah. Terms and conditions of appointment of service of employees. There's already, if I'm not wrong, there's already a procedure set up for that. It also says the terms and conditions for employees of the board are in the sixth schedule. This is again amazing. TDSAT has officially been given the appellate provision for against the orders and directions of the board. So TDSAT already has a bunch of procedures that is already informed. As I was saying earlier, it says call for information of data fiduciary or intermediary. Very interesting, because intermediary is not explicitly defined in the DPDP Act. Intermediary is a phrase that comes from the IT Act. So the rules are giving power to the board to call for information about an entity which is not explicitly defined. We'll need to get into this deeper, but yes, again, it does not say data processor, but it says data intermediary. Let me skip into what are the timelines of collection of information. So if you're in e-commerce, entity not less than 2 crore registered users in India. Very interesting. It says 3 years from the date at which the data principal has last approached the data fiduciary. As I was saying, it's like a limitation event that comes in. So if I log on to Flipkart today, but I don't log into it for as you say 3 years, then at the end of the third years, my data has to be deleted, and 48 hours before doing that, I need to be given an intimation. So online gaming intermediary, very interesting again. 3 years. Data fiduciary is just social media. 3 years. Okay, great. But for all purposes except, okay, we'll get into that as well. Social media intermediary is coming from the intermediary guidelines. Amazing. Class of data fiduciary. So I think I stand corrected. Section 9. Oh, okay. This is the government entities and what it will happen. Yeah, I think we can just skip that. And the terms and conditions of the chairperson and members. Again, the number of members are not mentioned over here. It just says chairperson and other members. Chairperson and other members. There is no mention about who is going to be a chairperson and what their terms and conditions are, or what their qualifications are going to be. These are again terms and conditions of the employee. They're having gratuity and leave and all of those rules, etc. Again, state instrumentalities, we can probably not really relevant unless you are a state official who are doing it. So great, absolutely amazing. The most significant highlights of these rules are appointment of data processor office, data protection officer. The rules going into force in incredibly short amount of time, while the act is not. I would probably, apart from that, the statutory recognition of what a security safeguards are, how contract between a data processor and data fiduciary is, what kind of things that you need to do, is immediately between in agreements and immediate processes. This is incredible. So this is just a quick run through about the whole thing. I have taken about quite a bit of time. So we'll come back with a detailed analysis. This is just a quick run through. Thank you. We'll post this on the Data Nuance website, and we'll have some more stuff coming on the Data Nuance website, datanuance.co and datanuance.co.in. Thanks.